Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. This is Ericka Adler. Welcome to the Health Law Hotspot. I am a shareholder and leader of the healthcare practice group at Roetzel and Andrus, and today I am joined by my colleague, Christina Kuta, who is also part of our healthcare practice and one of my favorite people to work with. We are both regulatory and transactional lawyers. So what we're going to be talking about today are physician recruitment agreements. And this is a pretty interesting topic, and I think it's one that people don't talk about enough. So I thought it would be really great for the two of us to really talk through what these recruitment agreements are and what some of the red flags are that physicians should be looking for when they're asked to sign a recruitment agreement. This is not something that is widely covered. It's not a topic that a lot of people really get into detail on. And unfortunately, Christina and I have dealt with a lot of physicians who have signed recruitment agreements without having it reviewed and haven't really understood the repercussions of signing that kind of agreement. So let's jump right into it. So first, we're going to have Christina kind of talking to us about what is a recruitment agreement, when is it used, and what are the guidelines for a properly written document.
Thanks, Ericka. So recruitment agreements are typically used in areas where a hospital may like to help bring a physician into the community for a certain specialty, a certain type of service that the hospital otherwise has a limited number of providers. So you might think that that's a great idea, that a hospital is being very altruistic to do that and really helping the community and the patients they serve by wanting to help bring a physician into the community. Unfortunately, with many things in the healthcare world, you can't be altruistic without actually looking at some regulatory issues that may limit what you can do and how generous you'd like to be. So with this particular issue with recruitment agreements, we're mainly worried about a regulatory law called the Stark Law. Many of you may be familiar, but Stark is generally a law that says you can't make referrals to an entity in which you have a compensation arrangement or an investment interest for certain services called designated health services if they're going to be otherwise paid by Medicare or Medicaid, generally a federal payor. So because of this, there are restrictions on what hospitals can do when they want to help a practice or a physician come to a community, establish their practice to really help the patients in the geographic area that that hospital serves. Stark does allow it, though, again, with some limitations. So generally, in order to comply with the Stark Law, you need to meet what we call a Stark exception. And for this purpose, there is a specific recruitment exception for Stark. And its basic purpose is to allow hospitals to provide remuneration to recruit a physician to relocate his or her practice to an area serviced by the hospital and be on that hospital's medical staff. And there's some very detailed requirements, but I'm going to go over sort of the basic outline of what they are. And then we'll talk a little bit more about them and how they impact the hospital, the physician practice, if a physician's coming to join a practice, and the physician individually, if he or she's just coming to establish their own practice. So for these type of arrangements, they need to be in writing and signed by all parties. So that means they need to be signed by the hospital and the physician. And if a physician is going to join an actual established practice in the hospital service area, that practice must sign on as well. The agreement cannot condition referrals to the hospital. It cannot say that the physician coming to the practice area must make all referrals to that particular hospital. And the amount of remuneration paid by the hospital to recruit the physician cannot take into account the volume or value of business expected or referrals generated for the hospital. Also, physicians have to be allowed to establish privileges at any other hospital they choose. Now, there are ways if the physician's joining an existing practice and has an employment agreement that may allow the employer to limit the place where the doctor can establish privileges, but the actual recruitment agreement to which the hospital signs on cannot make those limitations. Generally, when you're looking at what the geographic area serviced by the hospital is, to say that a physician has relocated to the area, you look at zip codes where at least 75% of the hospital's inpatients come from. There's a special rule that makes it a little bit more a little easier to follow for rural areas. And there's also some limited exceptions regarding relocating for residents and physicians who may have been employed by certain non-private practice entities, like a physician that was employed by the federal government. Like I said earlier, a physician can establish his or her own practice, or a physician can enter an already established practice. If a hospital is going to help recruit a physician under a recruitment agreement who's going to join an established practice already in the hospital service area, then again, that practice must sign on to the agreement. Any remuneration paid the hospital must go to support only that particular physician, except for some actual recruitment costs that the practice may have expended to recruit that physician. Otherwise, all monies must go to support that physician and only support incremental cost attributed to that physician. So for example, if an existing practice has 3 nurses working for it and a new physician is going to join, and that new physician is going to need their own nurse, then the recruitment money can go towards supporting that 4th nurse, but it can't go towards supporting the 3 nurses that were already at the practice before this physician joined.
Right.
The practice must keep records for 6 years of all the costs and how it used the money, so it can be reviewed by the federal government if necessary to show START compliance, or by the hospital. And it can't take into account any business generated for the practice, by the practice for the particular hospital that's entering into the recruitment agreement. That's generally the overview of what's required on the recruitment exception for Stark. And if you can meet all those particular requirements, then you're accepted from Stark's prohibition on physicians taking money or having some sort of compensation arrangement with an entity to which they refer patients.
Right. And that's a great summary. And I guess one thing I'll just clarify is that pretty much every group is sending patients to the hospital, and START covers everything. It covers radiology tests, lab testing, inpatient services. So most likely any group receiving support from the hospital is in a position to refer. So in case anybody out there was wondering, well, how do we know if START applies? You know, if the group is sending anyone to the hospital, most likely it's going to apply. So
yeah, I could think of a very, very limited circumstances where Stark wouldn't apply to a recruitment agreement.
And yeah, absolutely. I guess if you had a hospital that didn't bill any federal payors, maybe it wouldn't apply, but I don't think I've ever seen that either, right?
Yeah, I have not, no.
Yeah, me neither. So Christina did a great job of kind of outlining what Stark requires. And I think she'll agree with me that when you get the actual agreement, you know, it's not always written out quite the way she described it. So usually the first part will talk about, you know, the hospital has done research and agrees that there's a shortage in the community. That's something I always see written in there. And the first thing I always say to my doctor is, do you think this is true? Is there a shortage in the community? I hate to say that people aren't honoring this, but I have dealt with many, many groups where I really do doubt that there's a shortage in the community, either because once the doctor gets there, they're not very busy, or even worse, there is a situation where the physician is recruited to the area, and we're going to talk about what happens, you know, when they receive the money and have to be in the community. But very often, once that money kind of dries up, I sometimes find that my doctors actually don't have a lot of work to do, and there isn't a real need in the community. And Christina, have you seen that happen as well?
I have seen that happen. And it's interesting. I see it happen mostly in more urban areas where, like you said, you kind of think from the outset, well, is there a real need here? But the hospital has attested to a need. The practice says, no, we need other people. I've seen it happen a lot with surgery practices and surgeons groups where they'll say, we absolutely need another surgeon here. You know, we have the need. And then you'll see that that new physician who did relocate is not very busy, or is busy for a period of time. So maybe for 6 months, there was a situation where there was just an influx of patients in a particular specialty or a particular type of surgical procedure. And then, you know, for the next 6 months, they really aren't busy at all. And then you have to think, was there a need here? You know, this is an urban area where there already were a number of existing physicians in this type of practice. You know, was there a need? Can you meet the Stark requirement if now someone looks at these records and says, well, this doctor's not very busy, or the practice as a whole is maybe not that busy. So, those are challenges and things you have to think about at the outset. When a physician's going to enter into these kind of agreements, you don't want to be stuck not being busy. You also don't want to be stuck taking money when one of the requirements to take that money is you are needed and necessary in that case.
And I think that's really important. So when you actually get this agreement, there's a couple of different versions of the agreement I've seen. Most of them will provide support for the physician in the community for a period of time. So they come up with a fair market value compensation that's going to be paid to the doctor. And often there could be some signing bonus or other recruitment amounts. But generally, what's going to happen is that the physician is going to start working the practice and is required to commit to be there on a full-time 40 hours per week serving the community. And every month, the group is going to be required to turn over to the hospital a statement of the amounts that were received for the physician's services and the incremental expenses, as Christina defined it, that were incurred for the doctor. And the hospital is going to look at that report, and then they're going to say, okay, you brought in X amount and we have guaranteed you Y amount, so we're going to give you the difference. And so over time, and most recruitment agreements I've seen provide support for a period of 1 or 2 years at most. So during that period of time, we're going to see the hospital paying less and less, hopefully, as the physician's practice gets busier and busier. But at the end of the day, when that support period is over, they're going to then look and say, all right, how much money did we give you? And what is the total amount that has been provided? And that's generally how it's going to look. What the next step is that's really important is once we have that total amount, what happens? And the second part of a recruitment agreement is going to be, hey, guess what? If you stay for a certain amount of time, you don't have to pay us back that money. And that requires the physician to then agree to stay for another 1 or 2 years, depending on the amount of the support from the hospital. And over time, that's typically forgiven. I like to see, for example, it's forgiven 1/24 per month for 2 years. Some places like to do it, 50% and 50%. I don't like that approach. I think it should be given sooner. But here's the key thing. If the physician does not continue to work on a full-time basis for that entire forgiveness period, guess what? The money has to be repaid. And this is the most important thing for doctors to understand, because what happens if the reason for termination is not just the doctor deciding to walk off? The doctor dies, the doctor becomes disabled, the group lets the doctor go, the group breaches the contract, etc. So there's a lot of reasons that relationship can end. And what Christina and I often see is you have a doctor who's now on the hook for however much money. I've seen up to $1 million be provided as support, and they have to stay in the community for a certain amount of time. Now, the reason I bring this up right after Christina and I talked about the need in the community for the doctor is that typically, as long as the doctor stays in the community and continues to service the hospital service area, there's no obligation to repay. The question is, can the doctor stay in the area to meet that obligation?
And oftentimes, if a doctor comes to the area and joins a practice that's already established, and then they leave that practice, it's difficult to stay in the service area and maybe start your own practice from scratch. So if there are other practices that do the same type of specialty and work you do, but they're really not needing people because maybe the need wasn't that fantastic in the service area for your services, now you're in a pickle because you really are having trouble joining another practice. And it's very difficult just logistically, administratively, and financially to start your own practice, particularly if you maybe weren't that busy in the practice that you came to be recruited for in the first place. So, doctors really need to think about that and think about logistics. When you're joining a practice and you see this recruitment agreement and there's a guarantee of a certain salary, it's very positive. Everyone's happy. Everyone likes that. But you always have to think about the exit. Nobody wants to do that when you start an agreement. You want to keep positive when you're starting a relationship. You want everything to be great. You don't want to think about the end of it. It's like you get married. You don't think about the divorce when you're getting married, right? But in this instance, you really have to, because if you don't have someone looking out for you and you're not looking out for yourself with respect to how this could end, it could end badly for a physician Or a group on the flip side, what if a doctor breaches their agreement? The doctor was horrible. There was huge issues. The practice had to let them go. Depending on the recruitment agreement, that practice could be on the hook for up to $1 million that we've seen for a doctor that just was horrific and never was going to be a good fit for that practice, unfortunately.
Right.
So there's a lot of things you have to think about at the beginning, even though it involves the end.
Right. Absolutely. And, from the physician perspective, though, because way more often I see the doctor getting stuck with the repayment obligation, some of the things for them to think about are, is the time frame for forgiveness too long? If you got a $50,000 signing bonus, why should you be committed for 3 years? I see people, getting only 2 years for $500,000. So think about the length of time you're committing. Secondly, if you're getting money over time, but guess what? You've now gone several months and you haven't needed any support from the hospital. It doesn't look like you're going to need any. Why not end the support period then and let forgiveness start? That can generally kind of take that off your back because it gets forgiven sooner. Those are timing issues that I think are really important to think about at the beginning. And it can make it a lot easier. Let's say the doctor stays there forever and has a great relationship, then fine. But
we've seen that happen, it works out great.
Yeah, but in case it doesn't, at least you don't have to stay as long. And that's really kind of what we're going for. Now, the other thing to think about is shifting the burden away from the doctor. So Christina and I mentioned some situations, it doesn't work out with the practice, death, disability, et cetera. So for death and disability, I definitely like to see that amount just forgiven. A lot of hospitals, unfortunately, though, will say too bad, get disability insurance, get a life insurance policy.
And they're always concerned about, because the tax exempt status with hospitals, they're often very concerned about giving money and having it look like it was a, sort of a benefit, and it's going to be an issue with the IRS. So there's always that piece with most hospitals too, of why they're not apt to say, even if somebody dies, heaven forbid, let's just, forgive it.
Yeah, I think you just have to talk with your financial planner, your accountant, whatever, before you sign one of these to make sure that your family is taken care of in case they do come knocking at the door. The other thing is shifting some of that burden. If you're the doctor to the practice, a lot of times the practice employment agreement, which we're going to talk about in more detail, will say something like, no matter what the recruitment agreement says, doctor, you're responsible for 100% of any obligation to the hospital. And that's simply not fair. And, if everything works out and, let's say the doctor leaves the practice, but easily finds a spot in the community, then great, everybody's taken care of. But there are situations where it's simply not fair. Maybe like Christina mentioned, the hospital, the group breaches, maybe the doctor just walks away. I could see the doctor, and group kind of working out these details, but what we really want to do is make it fair. And, for example, the group has to turn over financial reports to the hospital on a monthly basis. And if the group's not doing that, or they're not accurate, they're not sharing all the right information, that's a breach of the recruitment agreement, and it can cause everything to become automatically due and payable. That's not the doctor's fault. So I like to see kind of those nuances worked out to make sure that everybody's taking responsibility for their own conduct.
Absolutely.
And those can easily be negotiated. Most hospital lawyers are willing to listen to those kinds of arguments. I can't promise that they're willing to make the change, but I think sometimes just knowing what you're signing, the good and the bad, is really what doctors are looking for, right?
For sure.
So let's talk also about the contract between the physician and the group itself. And Christina, I know you kind of mentioned restrictions that the group might place on the doctor. So why don't you speak to that?
Sure. So even though the recruitment agreement itself has particular items and terms that need to be in there to meet the Stark requirements, the employment agreement between the physician practice and the physician is not necessarily stuck with those additional kind of terms. So one of the things you always want to think about is, my recruitment agreement I've signed says X, but my employment agreement says Y. So I always tell doctors, one of the things you want to do at the beginning is make sure they're somewhat consistent and they're not contradictory, to where the practice has told you need to be bound by this, but the recruitment agreement has told you need to be bound by something else, and you can't possibly meet both those obligations. So that's one thing to consider. With respect to some restrictions, Years ago, it used to be that Stark didn't allow any sort of restriction on practice, what we typically consider a restrictive covenant for a physician. That is no longer the case. Practices are allowed to impose what we call reasonable restrictions for a restrictive covenant if someone leaves the practice. So, what is reasonable can be debated, but generally a practice can say, look, if you leave our employment, we don't want you working within, let's say, 5 miles of our office. And as long as the geographic area serviced by the hospital is much bigger than that 5-mile area, then that's probably a reasonable restriction. And the employer can actually make that restriction in the agreement. The physician then has to consider, okay, if I sign this, am I going to be able, if I leave here, to find employment outside that 5-mile restriction? Is it going to be easy? Are there areas for me to go? Are there practices that do what I do? Would I be interested in starting my own practice in that area? Because otherwise, as we've been talking about during a forgiveness period, if outside that 5 miles, it's going to be very difficult for you to practice, you're going to run into issues with potentially the forgiveness period. One thing Stark doesn't prohibit, and I see often in employment agreements and is perfectly allowed, are other restrictions generally related to solicitation. So not taking patients with you, not contacting your patients, not contacting the practice's vendors or their referral sources. Those aren't restrictions that are actually addressed by Stark and are fair game in employment agreements. And typically those won't be even discussed in a recruitment agreement, but your employment agreement is going to say, hey, if you want to leave here, that's great, but you're not contacting your patients to take them with you. It's another consideration. Will you have enough work in the area if you can't actively contact your patients and they have to kind of find you to be able to continue to provide services?
Right. And sometimes a recruitment agreement will say there can be no restrictive covenant in the employment agreement, and yet there still will be one. And, the doctor's caught in the middle, like he's not allowed to sign an agreement that has a restrictive covenant in it, but the employer won't take it out. So that's an awkward position that we sometimes find ourselves in. Another situation that I have come across with recruitment agreements is that very often, the same group just recruits doctor after doctor after doctor. So they get support, it's forgiven or paid back depending on the situation, and then yet another doctor comes in. And I see kind of like these repeated relationships, very often tied to a questionable need for the doctor in the first place. So I think every doctor should kind of worry where, there's just been this years and years and years of this relationship. I've even, where there's a close friendship between the hospital and the group. I've actually had one lawyer kind of doing the contracts for both the hospital and the group. I think there's definitely a conflict there.
Sure.
And I think, in some cases, this recruitment exception is being pretty much abused. And I think, doctors really need to just be very careful to look for those kinds of red flags. I don't know if you've seen that.
A few months ago, I actually had a practice that recruited someone and they were excited because I kind of thought about it as like free money. And I said, well, kind of, but with a lot of strings attached. And the biggest attached string is, again, if this doctor really wasn't needed, if there wasn't a need for this in the service area, and right, your buddy at the hospital says, hey, we can do a recruitment agreement with you. We do this all the time. Let's go ahead and help support, you bringing somebody in for a couple of years. The problem with that is you've got the Stark law. And like we said, it almost applies in 100% of these situations. It's a strict liability statute. So if you don't do everything right under it, there's no intent, there's no motive, there's no nothing. You have violated it. And violating the Stark law is not a fantastic thing. It's going to involve having to deal with the government. And unfortunately, every time that doctor who was recruited referred to the hospital for a designated health service, that's money that may need to be paid back to Medicare for those claims that went through. So you've got to be careful. And if you're a practice, and not just think of this as like a revolving door of credit to be able to keep bringing in new providers. That's not what it's intended for. And it can get you in some trouble.
Right. And I guess, not to belabor this point, but we've had many physicians sign recruitment agreements where either their relationship ended or something went wrong, and they have been unable to sustain themselves in the community to earn that forgiveness. And they have been virtually destroyed financially as a result of these arrangements. In various situations, we've had litigation We have reported to CMS about violations of Stark, and pretty much all of these had to do with as you call it, revolving door, where there really was no need in the community. And this is not really being policed too much by anyone. So it's something really for doctors. When you get your employment agreement, you don't want to have it looked up by a lawyer. Great. But it's really not smart to sign a recruitment agreement without having somebody look at it, because that's one that can affect your credit and can affect you for many years to come, and they will chase you down. And so I think that's a really important thing for everyone listening to this to understand.
Absolutely. And someone who understands recruitment agreements and has some familiarity with them, because there are so many subtle nuances and laws that apply, that you really want to have someone look at this who has done this before and understands the recruitment agreement and all the exceptions that apply.
Definitely. And, one other thing I'll mention is that I have had some challenges in getting language modified in recruitment agreements, take into account a physician who might be on maternity leave or a physician who might become disabled. Remember that most recruitment agreements require full-time commitment in the community. So anything less than full-time is technically a breach. So it's really important to also make sure that the language is sensitive enough to take those into account. And unfortunately, just because the hospital lawyer is the one putting this together doesn't mean they're super savvy or really knowledgeable about the law or about recruitment agreements. And often it's just a form that they use. In fact, some of the big hospital corporations use the same form across many states and then simply don't care and won't make any changes. So I think it's really important for the doctor to understand what they're signing. We just see too many unfortunate outcomes from recruitment agreements. I don't want to leave the impression that recruitment agreements can't be great, because when they work really well. The doctor's happy, the group's happy, etc. It's for that time when it doesn't work out well, where it can be quite devastating, and I think it's preventable.
Absolutely. The purpose is great for the community, and when there's a need, it's fantastic to be able to provide that support and bring in physicians that can help service the community. But unfortunately, in rare circumstances, it can go poorly. And hopefully the information we provided today will help people not get themselves in those particular situations.
Right. So I think that those are the main points that we really wanted to share. And hopefully, if you're looking at a recruitment agreement, you're working with a great lawyer, and the hospital lawyer is flexible and understands the concerns of all the parties. I think when a team can come together, this can be a great document. And hopefully that's the situation that many doctors will find themselves in. If not, they're going to need people like us to help. And, a healthcare lawyer, depending on, what state you're in, et cetera, will be able to provide great advice on this topic. I think it's one that's maybe not talked about enough, though.
Sure.
All right. Well, thanks, everyone. Christina, as always, I appreciate you joining me to talk about this. And this has been the Health Law Hotspot. You can see more of our topics and our past podcasts at ralaw.com and on YouTube at Health Law Hotspot. Thanks for joining us.
Bye.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.